Next case on the calendar is Sanfilippo versus State of Florida. Counsel, you may proceed.
Good morning, Your Honor. For the record, may it please the Court, Ross Keene on behalf of Stephen Sanfilippo. I'd like to reserve 2 minutes, please, of my 10. Your Honors, this morning I'm going to address Issue 2 from our briefing only for purposes of argument. That issue, Your Honor, is whether or not the trial court erred in denying Mr. Sanfilippo's motion for judgment of acquittal as to 14 counts of providing false information under a derivative of the construction lien law, which criminalized providing false affidavits in which there would be reliance by somebody. In this case, it would be the closing representatives regarding all of the construction sites and projects that were closed by Mr. Sanfilippo. There is, under that statute, first of all, there is not a lot of case law on this, and I think it is an issue the state that the court should address and listen to for purposes of oral argument.
Counsel, while our review here is de novo, are we not obligated to consider the evidence and all reasonable inferences from that evidence in a light most favorable to the state?
Yes, Your Honor, that is the JOA standard.
And it seems to me, as I read your brief, you're really arguing inferences from the facts in a light most favorable to your client.
Your Honor, this is not an effort to reweigh, which I know this court scrutinizes strictly in looking at criminal matters coming before the court on sufficiency arguments, including those coming in light of a JOA request. But no, we are not doing that. I believe that in looking at this, and I think the statute, the language of it is important because it has a very, very strong intent requirement. And I concede that the state correctly cited in its brief that intent arguments should not be one subject to a JOA granting by a trial court. I mean, that is for the finder of fact, and this was a jury trial, and we concede authority to that degree. But I think on this what we need to look at, and again, there is not a lot of authority on this. This is a statute that has not really been used and charged in this context very much. And I think for that purpose there is a very, very strong intent requirement on that. And I do not believe that we are simply looking at the facts, spinning it our way in our briefing. I think that in looking at the facts and looking at the competent substantial evidence that we would need to for purposes of addressing that, I think that the evidence can come before this court for consideration. And I think that the evidence was very clear on that. There is a requirement that there be a knowing and intentional provision of information. And there were witnesses, and again, even in the light most favorable to the state, witness after witness, uncontradicted really by the state, as to the shambles, for lack of a better word, of the financial bookkeeping and accounting at Anthony Homes. Now, Mr. Sanfilippo was charged individually with these counts. He was charged individually in this information. There was a racketeering count, and the enterprise did in fact include Anthony Homes. We've briefed that issue, and I would ask that the court reverse on that as well. But for purposes of looking at this statute, this is an individualized application of Section 713.35, and it has a very, very strong intent requirement. And there was an abundance of evidence. Judge Van Nortwick even viewed in the light most favorable to the state, where it can show that Mr. Sanfilippo came in unknowing. He didn't know exactly what was or was not entered. Now, that begs the question, shouldn't he have done that, and would that, therefore, if you will, even a recklessness on his part of coming in and not knowing, would that be enough to establish the intent component of this to convict under those? And we would assert that it would not, under the strict knowledge requirements that we have here. Mr. Sanfilippo may have joked. The state, I think, made reference to Mr. Sanfilippo's comments in a couple of the other issues about, well, you know, they're going to get me sometime. Or
so a party executing an affidavit as to certain facts, financial facts, knowing that that person's office is a disaster or a mess or whatever the words were, can't be, that's not sufficient to go to the jury on whether that was sufficiently intentionally misrepresented?
I don't believe under the context of the facts that we have, and I think the record, and this is a voluminous record, it's I think 26 volumes on this, but if you go through and look at it, there was testimony from the very witnesses that appellant relies upon in asserting this argument. There was a great deal of testimony as to, number one, there were recognized problems, but number two, Mr. Sanfilippo, as the CEO of Anthony Homes, took steps to correct that. He fired some people. Some people were left under pressure. They retasked some of the responsibilities on the financial end. And those were ongoing efforts to improve a situation that he had. But the bottom line is, did he know when he went into the closing of the specific affidavits that we have in this case? And again, we're focusing on 14, 70 years worth. They're third-degree felonies. We're focusing on these 14. The testimony as it relates to that, as was brought out at trial, suggests that in his mind and based on his conduct and the witnesses as to these 14 closings, there was no evidence that he did in fact know what was going on or that he knowingly provided false information in the affidavits. He executed the affidavits, there's no doubt about it. There was also trial testimony that some of the affidavits were executed in advance prior to the closing. But I think the second half and the second component of our argument in this is also that many of the contractors, it was the state's own witnesses that were testifying as to when they provided the information. I mean, there was an impossibility with many of them that the information could have even gotten into Anthony Homes and consequently Mr. Sanfilippo's hands at the time it was executed. Now, was there indifference perhaps by pre-executing or executing an affidavit before all that came in and going to a closing with essentially a blank check affidavit signed? Perhaps. But applying the proper intent standard, I think, in this case, and again under this statute, and there is not a lot of authority on the specific intent and the state of mind elements of this charged statute. I think if you factor that in, I think that is where the court can look, and I believe that the trial court could have exercised its judgment of acquittal powers and granted it as to that case.
I mean, I understand your point. I mean, the sort of a long-term sloppiness in handling these home closings where sort of everybody knows that all of the I's have not been dotted and the T's crossed, but it's sort of close enough to close, and it's gone on for years, and that's been probably the general practice in the industry there. But your client got trapped, and I guess your argument is sloppy doesn't equal intentional.
Yes, sir. I mean, that is a paraphrase that I think I could certainly expound upon, Your Honor. But yes, I think that in part, and I think the facts support this, and it's not disingenuously put before the court on that level to come in and say. I mean, it wasn't, in this aspect of it, there was some testimony at trial as to just he's a bad businessman, but he built a great house. I uttered those words myself at one point in the trial, and I think that there is a degree of truth to that. But I think for purposes of these affidavit counts, there is a much stricter standard, and I think that if you apply the facts of the case, and again, with the in the light most favorable to the state, I think that the statute is not satisfied with respect to these 14 counts. I'm into my rebuttal time. Thank you.
Good morning. May it please the Court. Terry Roberts for the State of Florida. The false statements, argument 2, there was sufficient evidence to support the jury's verdict, and it was proper for the judge to deny the motion for judgment of acquittal. There was specific evidence that Mr. Sanfilippo knowingly and intentionally wrote false information or completed false affidavits, knowing that the homeowners would rely on them and induce them to make their final payments at closing.
What was the evidence that he knew his affidavits were false?
Well, first, I know Judge Van Ortwick, you brought up that it seemed to you like the appellant was maybe casting the facts in the light most favorable to the appellant, and that's right on point. While the appellant blames bad bookkeeping and the bookkeeper for what he calls a mess, basically, of paper, the accountant, Rochelle, the one that was blamed for this mess, she testified at the trial, and her quote was that she often, that was the quote, informed appellant that Anthony Homes was in arrears and behind on paying subcontractors. That's in volume 6, pages 614 through 616 and 626 in the record. So she told him, we're $500,000 in debt. That number was in 2003 when a lot of these, I mean, there's several different victims, but that's around the time period all this was going on. We're $500,000 in debt. We don't have enough money to be taking on all these jobs. And of course, I know we're not really addressing the racketeering and organized fraud issues because the appellant's narrowed his argument, but that bleeds into the false statement argument in that here was Mr. Sanfilippo taking money, not performing contracts, and pouring that money, siphoning that into the building of his own private home. He had to know that he wasn't paying the subcontractors. His accountant told him, and he was using the money for other things, about $700,000 of homeowner money and money that was supposed to go to subcontractors. When he was confronted by attorney David Braslow, who was the attorney who handled the closings, attorney David Braslow testified he noticed that there was a pattern where Mr. Sanfilippo was filling out these affidavits saying there's no outstanding liens or payments to subcontractors. He pulled him aside and said, what's the story with this? And Mr. Sanfilippo said, yes, I know, I'm having financial problems and I have to execute these. He didn't say, I wasn't aware of this problem, that there's outstanding liens. Even the attorney was able to pick up on this, and he didn't work for Anthony Holmes. He was just there to represent for the purposes of the closing. And he said,
the attorney was the lawyer for who in the closing?
I can't recall precisely who he represented. He wasn't an Anthony Holmes employee. He didn't have any inside knowledge. He just noticed that there was a pattern of he didn't exactly specify how he knew, but the important point in the record, and this
the
is
closing lawyer is often paid by the bank.
Well, most of these cases, that's why my memory's failing me. Right. Most of these cases, and this is more pertinent to the first and third issues, I think every case, I don't want to say every case because there's so many victims, but almost every case that I can think of, these were all cash payments. He encouraged all the victims, don't use a bank loan that's going to slow everything down. Give me cash. So that's the reason that I don't think he was a bank employee in this case, so I can't recall exactly about it, but he certainly owed a duty to everyone that was at the table, and what Mr. Sanfilippo said was, I'm doing this for financial reasons, not this is something I'm not aware of. There were statements to his accountant that he knew he was in financial trouble and he was taking on these additional jobs and building his own private home to use as a showcase, to bring in more business. In other words, it was almost a gambler's sort of rationale of, I'm going to put more money into this to catch up, I'll pay everything off, it'll all be fine in the end. So he definitely knew that there was money outstanding. And you have to notice under issue 3, the quote from the appellant's brief is, while he's blaming the accountant for everything under issue 2, under issue 3, his quote is that he was the sole person responsible for the affairs of Anthony Holmes. That entire phrase I just read is an exact quote in the initial brief on page 59. Also, what this really boils down to is the sheer number of encumbrances and outstanding debts are hard to chalk up to, well, these were just a bill that came in late. Not that it's okay to say that to sign an affidavit and when there could be something outstanding, but when you look at this, the jury was more than entitled to come to the conclusion that Mr. Sanfilippo knew what was going on. There was a $77,000 encumbrance and a $10,000 lien on the Morgan home, a $95,000 outstanding debt on the Weeks home, liens on the Books property, 19 liens worth $82,000 on the Guy Rings property. He told the Kings that he forgot about the liens and that he would make good on it, but he didn't pay that. There were unpaid liens on the Smiley's property. There was a previously undisclosed lien on Davis's property that was filed prior to the closing. This was absolutely a pattern, and again, this all bleeds into the other counts in here, but you can see through a pattern of there are approximately 40 victims. I think there were 11 families, so about 22 homeowners, and 18 different subcontractors. And when you look at the victims, the homeowners were owed $500,000. The subcontractors were out a total of about $250,000. That was a stipulated restitution amount. This simply can't reasonably be ascribed to, and I don't mean to act like I'm doing a closing argument here. I'm trying not to be drawn into that, but that's a bit what it feels like. The jury absolutely was entitled to say that this $250,000 that was outstanding at the time of trial, and it was more than that when the charges were filed. He paid some money back, probably, I'm just guessing, but in an effort to sort of minimize the crime by the time of trial. That's one of the arguments, is I paid part of this back. But there was still $250,000 outstanding here at the time of the trial. So to say that this was just a few bills that were late or unaccounted for, when he was the sole person who had access to the checks, the sole person taking the checks to the bank, and his accountant was telling him we're $500,000 in debt, and he's saying, I know, but I'm in financial trouble. It's impossible to say that the jury didn't have any authority to conclude that he knew he was signing false affidavits. I think the most telling fact was James Foster, the subcontractor, who called and said, you know, you told me that when you sold your house that you were building, you would pay me back, and he wasn't able to pay him back because he was so far in debt, and he told Mr. Foster, get over it. I mean, this shows the level of callousness that Mr. Sanfilippo had towards both the subcontractors and the homeowners whose money he was taking, not performing a contract, and building his own home where he made a profit, a personal profit of $300,000, but he was also funding his enterprise, Anthony Homes, through that because he was using the home as an advertising piece to bring in more business that he hoped would get him out of debt. So I think that the evidence is more than sufficient to conclude that he knew he was very in debt and that he hadn't satisfied all the bills at the time of all of these closings. So with that, the state would ask that this court affirm the judgment.
Thank you.
Just very briefly, if I can respond. The state, I think it's interesting, cast general factual aspersions on Mr. Sanfilippo with respect to broader trial testimony on the racketeering issue and the organized fraud issues. And we had a brief that was outside of page limits on this by the court's approval. It was a 26-volume record on this. There was an awful lot of testimony, but I think it's telling that counsel did not specifically refute the specifics of the 14 counts as to the affidavits. There were general references made by the state of the $500,000 that one of his prior bookkeepers said, you know, we were in debt for, but there was no link to that $500,000 being linked to one of the 14 counts regarding these false affidavits. Ms. Rochelle was, in fact, one of the individuals behind it. She was one of the people that lost her job. Of course, you know, it could be understood her testimony would go in that way. To answer Judge Van Nortwick's question, Attorney Braslett was actually counsel for the title company. And again, as far as linking him to any of the 14 counts that we're discussing right here, he was referenced in various trial testimony, but as to these 14 and the specifics of the facts on these 14 false affidavit counts, I don't believe that Attorney Braslett's testimony in any way went to the facts that would go to Mr. Sanfilippo's state of mind and intent. And as to whether or not Mr. Sanfilippo was saying he ran the show in count 3, but in count 2 we're saying, wait a minute, my inferiors are the ones that provided me with bad information. There's no doubt that Mr. Sanfilippo was calling the shots across the board. He was the one that went in with the laptop computer that was based on the data that was from the entry clerks at his office, and that's what he set up in the closings, and the record shows this. That's what he set up in the closings. He looked at it, and if the status of the job was paid, no record of a lien, no record of any outstanding obligations to any subcontractors, he gave him the affidavit. And to the extent that there's any suggestion of the intent behind that, I don't think that the facts would support that, and I think the trial court should have granted the JOA on this. As to the other issues, we would ask that the court also reverse, and again, we'd stand on our brief. Thank you.
Thank you, counsel.
Thank you. Thank you, counsel.